SJC-12887, Commonwealth versus Jose Lora.
Attorney McDonough, whenever you're ready.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court. My name is Jaleese McDonough, and I represent Mr. Jose Lora. Ultimately, whether we review the errors in this case as substantive errors or ineffective assistance of counsel, we reach the same result. Mr. Lora did not receive a fair trial due to a substantial risk of miscarriage of justice.
Can we start with the jury instructions? You're saying that he should have gotten certain instructions, but he didn't ask for them, right?
Yes, Your Honor. The instruction as to whether Kevin Parker's prior instances of violence should be considered was briefly discussed during the charge conference. Counsel may have withdrawn the request, but as far as whether it should have been given, I think the request was withdrawn because Mr. Lora testified that he did not know that Mr. Parker shot him. But there was other evidence in the record that Kevin Parker had prior instances of violence directed at Mr. Lora that could have been considered by the jury in determining whether Mr. Lora reasonably apprehended death or serious bodily injury.
Can you explain that, though? If your client testified he had no knowledge of it, and I think he really doubled down on that and was asked multiple times and said, I didn't know, how is that relevant?
Your Honor, I think it was relevant because that would have come down to a question of fact for the jury. There are at least 3 other witnesses who testified that Mr. Parker did shoot Jose Lora. Mr. Parker himself admitted that he had shot Jose, and 2 of the witnesses who were in the vehicle with Mr. Lora, Ms. Forget and Ms. De Los Santos and Mr. Taylor, both testified that there were rumors that Kevin Parker had shot Mr. Lora. So I think under Commonwealth versus Clementi, it would have been a question of fact as to whether Mr. Parker did in fact shoot Mr. Lora. And the Commonwealth argued extensively in closing that the jury shouldn't credit any of Mr. Lora's testimony. So the jury could have found that Mr. Parker shot Mr. Lora knew, and that this was relevant to whether Mr. Lora was in reasonable apprehension of serious death or serious bodily injury. But other than that, even if we don't base it on that.
I'm sorry to stop you. Go ahead.
Sorry, I've got to stop you there, though, because you're glossing over the threshold question of whether or not the judge, in the absence of a specific request from the defendant, was to look at, as you say, the totality of this evidence and give the instructions to respond to it. That's not our law, is it?
I'm not sure that it's. There is one case that does address it, which I outlined in my brief. We still look to whether there's a substantial risk of miscarriage of justice, and I think it was based on the counsel withdrew the request based on the faulty premise that the only evidence was whether Mr. Lora was shot by Kevin Parker. But there was also this other evidence of Mr. Parker admitting that they had other violent occasions between them.
Well, just answer this one question.
Yes, Your Honor.
Was it error for the judge to not give an instruction that the defense did not ask for?
I think it was error, and even if not, then it was ineffective assistance. And I think the case that I cite in my brief addresses it in both ways, whether it's one, whether the court should have sua sponte given the instruction, and in the alternative, if it was not, whether counsel was ineffective for not pushing the issue as to whether Mr. Lora should have received the instruction. And it's both analyzed under a substantial risk of miscarriage of justice, whether we look at it from an ineffective standpoint or whether it was error.
Let me follow up with you on that point then. So if you're saying that irrespective of the initial framework, we still get to the same question. So the defense in this case pursued this defense that it was PTSD based and hypervigilance, and that's why it was proactive as opposed to reactive. So that being said, you had testimony from the clinician about Mr. Lora's alleged PTSD and the reasons for that. And the judge also gave an appropriate instruction to the jury that they can consider all of the testimony, all of the evidence that bears on the defendant's state of mind when it comes to this issue of reasonable apprehension. So tell us how it is that you meet the standard of substantial miscarriage of justice in the event that you say it doesn't matter whether he gave it or didn't.
I believe that he's prejudiced either way because of the fact that his entire defense was premised on this mental impairment defense, and the jury was never specifically instructed that they could consider mental impairment. We have a specific instruction for that purpose that's a part of the self-defense instruction that specifically says the jury is able to consider credible evidence of the defendant's mental condition at the time of the killing. So I think this, they were, but they weren't specifically instructed that they may consider the defendant's mental condition specifically bearing on the issue of whether Mr. Lora actually believed he was in danger. And they were instructed, you can consider all evidence, but I think we have this specific instruction so that the jury knows they are to consider directly on that point whether there was a mental condition that could have affected whether he reasonably apprehended death or serious bodily harm.
One of the things the Commonwealth points out about the argument that you're currently making is that the rest of that instruction talks about whether a reasonable person in those circumstances would have believed he was in immediate danger. Can you address that part of the instruction?
Yes, Your Honor.
And why it wouldn't have been reasonable for counsel to make a strategic decision to say, you know, I can't fit that unless we look at the PTSD of this particular subjective defendant?
Your Honor, I think as far as the strategic decision, counsel's entire defense was premised on the PTSD. So I think to say that he would have called an expert, had another police officer come in and specifically testify about this incident where Mr. Lora was standing next to a friend when he was shot, all of this went to the defense's entire defense.
But that's his subjective feeling. You know, my question is about the Commonwealth's argument that in addition, that instruction, the second half of the instruction that you're requesting now,
yes,
requires that a reasonable person have reacted the same way.
Your Honor, I think taking that portion of the instruction as it interplays with the portion of the instruction that talks about mistaken belief, I think taken together could have demonstrated that, because mistaken belief does not apply to kind of the subjective component. So the jury was also instructed a person may use deadly force to defend himself even if he had a mistaken belief that he was in immediate danger of serious bodily injury. So I think taking everything, all of the instructions, if he was to also receive the instruction on mental impairment with the evidence, the jury could have concluded that there was a mistaken belief and a reasonable person maybe could have had the same mistaken belief given all of the circumstances. So the fact that it's a rival gang member in the other vehicle, the fact that Mr. Lora was shot on 2 prior occasions, the fact that there was a number of witnesses who say they saw...
Shot on 2 prior?
Well, so he was shot 5 days before, and then he was standing next to his friend who was shot at 8 months before. And then the other witnesses who testified that they saw Mr. Parker reaching for something, and based on the look in his eye, it didn't seem like it was something innocent. It seemed nefarious. So I think taking all of those together, if the jury was properly instructed...
Actually, can I just press you on one? You used the plural of other witnesses. Wasn't there only one, Mr. Taylor, that was the only testimony that arguably could be viewed, I guess, in the light most favorable to you, that Mr. Parker was reaching for something?
Ms. De Los Santos, who was the passenger in the front seat, she had also testified that she saw Mr. Parker reach down for something. She did admit that she didn't say that before the grand jury, but she did testify to it at trial. So there was both Ms. De Los Santos and Mr. Taylor. Ms. Forget said that she was driving, so she was more focused on what was ahead of her than the other car, but there were 2 witnesses who did say that.
So I'm not saying this in isolation and because I'm going to relate it back to what you just said. So if we could focus on Mr. Taylor, because I do think Mr. Taylor's testimony is also bearing on the issue of reasonableness. So you say that the substantial likelihood is met here because if you take all of the stuff that's in the instruction he didn't get, coupled with the evidence that the jury likely could have come back with that. But Mr. Taylor says something different that undermines that. Mr. Taylor's letter to Ms. De Los Santos, I think it was?
Yes.
During the course of his testimony, a jury reasonably could have inferred that this had nothing to do with reasonable apprehension, that this was a retaliation, that Mr. Lora knew they were going to be there, used a ruse to get a ride to the cemetery, and that this was a retaliatory shooting for the shootings and the deaths that had happened with his rival gang members. So again, in the context of all of the evidence, you still say that he meets the substantial likelihood without this?
Yes, Your Honor, and I would make a couple of points as to the Fred Taylor letter. The Fred Taylor letter, the Commonwealth now argues, only came in for impeachment to contradict Mr. Taylor's testimony that it was kind of a happenstance encounter. And the trial court actually specifically found that it wouldn't have left the impression with the jury that Mr. Taylor actually believed this. He was reciting hearsay that he had apparently, it seemed he had been informed during his interview with police, which defense counsel tried to probe that a little bit more in redirect, but was unable to. But that information only came in for impeachment. So there was no direct evidence that Mr. Lora allegedly planned this incident and came to the cemetery in knowing that Mr. Taylor would be there.
I wasn't suggesting that it came in substantively. What I was suggesting was that that is evidence that bears on your client's state of mind, so that it's not coming in for its truth, but on the issue of whether it bears on his state of mind, that he's reasonably apprehensive of Mr. Parker, and that they could use that evidence on the issue of the state of mind to not believe that to be the case.
Well, yes, Your Honor, but I would go back to my point that it wasn't substantive evidence. So while it would have impeached Mr. Taylor, the overwhelming evidence was that this was not a planned encounter by Mr. Lora, that he showed up and looked over and suddenly Kevin Parker was sitting in the car next to him. And so our position is that the information in Mr. Taylor's letter shouldn't even have come in because it was double hearsay at that point, but that it really didn't undermine any reasonable apprehension because the overwhelming evidence was that it was a happenstance encounter.
And you know this record better than I, but just I want to make sure. Was there a limiting instruction when Mr. Taylor's testimony about the letter came in?
There was not, Your Honor, and the Commonwealth actually improperly used it as substantive evidence in closing. Instead of using it as impeachment, the Commonwealth directly argued, Fred Taylor said it best in his letter.
Did defense counsel argue for limiting instruction?
He did not request a limiting instruction. He did try to, it seemed, try to correct it on redirect, but his questions were objected to by the Commonwealth and sustained. Okay,
so just again for our analysis going forward, I'm sure we'll look into this, but if there isn't any limiting instruction that it was ostensibly supposed to be offered for limited use, but there's no limiting instruction, don't we have case law that says that it comes in for all purposes?
We do, and that would go back to my argument that it shouldn't have come in for all purposes. And the Commonwealth now argues that it was only for its impeachment value. But I would just point out for the court that the Commonwealth used it substantively in closing, and that it was error. It shouldn't have come in substantively, if at all, because of the double hearsay nature of the letter.
Thank you.
Now, if I could return to the errors at trial, I would like to address whether Mr. Lora was prejudiced by the errors. So I think there were three overarching errors in this case. So the prosecutorial misconduct, which occurred with the delayed disclosure of evidence, the improper cross-examination of Mr. Lora, and the improper appeals to jury sympathy, both during the testimony and during closing argument. Whether the gang...
You to focus on the prosecutorial misconduct that you allege. So the disclosure happened, it just wasn't as quick as the defense would like. How was the defendant prejudiced by the time lag in the disclosure? How would the defense have been different?
Yes, Your Honor. So as to the delayed disclosure, so there were the Facebook posts, and then there was the information as to the Obong shooting, which was the shooting 8 months prior. So as to the Facebook information, counsel could have filed a motion in limine as to the statements that were allegedly made on Facebook. So about earning your stripes. And then also, I don't fear my friends, or my enemies, I fear my
Would
friends.
that motion have been successful?
I believe it would have been successful, Your Honor, because it did imply other prior bad acts. In the court's recent decision as to the rap lyrics within the last year.
But that's different, because the case you're talking about, we were discussing that within the framework of character evidence. This is very different, because your entire defense is based on this reasonable apprehension. And so the state of mind is something that you're putting into your defense, and that's the central rudder of what you're saying. So these issues that the Facebook posts go to that very issue of your client's state of mind. And I'll also add one other thing before you finish answering Justice Wendland's question as well. The delayed disclosure, I wonder what are we to make of the fact that we have this affidavit from the trial prosecutor that this was one, your client's own Facebook post, and secondly, that so you ostensibly should have or could have been aware of them. But the central point is the state of mind is what's at issue as to the reasonable apprehension. How would you have kept it out on relevancy grounds?
Yeah, sure. As to the it being Mr. Lora's Facebook post, I will have to pull the citation, but I believe there's a case out of this court that says that counsel is not to expect that his client may share all information with him. So if counsel could have filed a motion in limine, then I think it's relevant. The Commonwealth's responsible for turning over statements of the defendant that they plan to use. Arguably, any statement that the defendant's made is known to him, but it's still under Rule 14 as information that the Commonwealth's required to disclose. And then as to your second point, this is directly relevant to state of mind. I believe the defendant also raised a self-defense claim in the recent rap lyrics case, and it did go directly to his state of mind. Here we're talking about statements, I earned my stripes, I did too much to get them. The Commonwealth claimed that Mr. Lora was already a gang member at the time of this shooting. So arguably any statement of I already earned my stripes would have implied prior bad acts that potentially occurred well before this shooting.
Well, it's not I earned my stripes.
I'll never drop my stripes,
Yeah.
I earned too much to get them.
That's right. And so isn't that different?
I don't think it is, Your Honor, because I think the Commonwealth tried to imply that
earning your stripes might suggest would be, maybe entrance into a gang. I don't know about these things, but it seems to be what you're suggesting. Keeping them, I will never drop my stripes. I did too much to get them. Seems different.
Well, the Commonwealth attempted to imply that the prosecutor actually did directly argue in closing that what did Mr. Lora do to earn these stripes? He shot an unarmed gang member who was sitting in the
vehicle. So I understand the argument. My question to you had been and still is, why would this motion in limine be successful? Because it seems relevant.
But I think they imply prior bad acts. Because if the Commonwealth's claiming that Mr. Lora already had stripes at the time of this shooting because he was already a gang member.
But these posts post-date the shooting at issue here.
They do.
Okay.
But if the Commonwealth is arguing that Mr. Lora earned his stripes by this incident,
Yes.
In order to undermine that, he would have to suggest prior bad acts.
Right, that's why it's not earning, it's about dropping.
I understand that, Your Honor, but I think viewing the totality, I think there was so much other gang evidence that they did little to add to the Commonwealth's case.
So that's my question for you then. Given that there was all of this gang background, how are you prejudiced?
I think in Commonwealth versus Wadsworth, this court cautioned against cumulative gang evidence and said that they have the potential to sway the jury with emotions. And taking that evidence along with all the other gang evidence that went beyond what this court allows in Wadsworth, it all created prejudice. So we have the statements from his Facebook post, but then we also have other cumulative gang evidence that was improper. So we have the prosecutor actually pointing to the spectators and saying, are these gang members, implying for the jury that Mr. Lora still associates with gang members. It was stricken, but I think it's one of those things that's so prejudicial that the bell can't be unrung. We also have the prosecutor admitting photographs of Mr. Lora, saying, "Don't you brag about being a gang member on Facebook." We have the prosecutor asking Mr. Lora about whether gang...
Counsel, I guess, but it sounds like you only want one half of this equation, because it sounds like Mr. Lora is saying the apprehension that he had was so great that he had to prospectively act because of this rivalry between these gangs. So how can you have your cake and eat it too? Because that's the central component to why you say he's so hypervigilant about his safety in the world, because of this underlying issue between the gangs.
I concede that the gang information was relevant. It was relevant both to the Commonwealth's case on motive and intent. It was relevant to Mr. Lora's defense, but I think it went beyond that as far as painting Mr. Lora as this person who's still associated with gang members at the time of trial, who was involved in drug activity because of his gang involvement, which we also couch in the context of opening the door to his prior drug conviction. We have Officer Roberge, who actually testified as to an improper opinion testimony revolving around the gang evidence. So gang members don't carry guns 24/7. They only carry them if they have the intent to use them. Mr. Lora had a gun on June 26th. So all of these pieces, while they are gang evidence and the gang evidence was relevant to the trial, they went beyond what the court says is permissible and went more into the field of playing the jury's fears and emotions surrounding gang evidence, rather than sticking to the issues of whether Mr. Lora was shooting due to the gang rivalry, and whether there was this feud between the two, and kind of swaying the jury's emotions and being fearful of gangs, rather than just deciding whether this was a component of the intent and motive.
Mm-hmm.
Okay. Thank you.
Okay, thank you, Your Honor.
Okay, Attorney Bodwin.
Good morning, Your Honors. May it please the court. Nathaniel Bodwin for the Commonwealth. Excuse me. Before I get into my argument, I do want to acknowledge that the family of the victim is present in the courtroom today. Your Honors, I would ask this court to affirm the defendant's conviction for first-degree murder because of the overwhelming evidence that was presented that he acted with deliberate premeditation, evidence which significantly undermined the defendant's testimony and his self-defense claim.
How is the jury to know, how are the jury to know how to use Dr. Brown's testimony?
As was discussed, there was an instruction given by the judge that said the jury could consider all circumstances surrounding the defendant's state of mind when deliberating. And I think it's also important to note that when you look at that I think the primary defense here was self-defense, and the PTSD was sort of a secondary periphery defense. And Dr.
Well,
Brown—
I thought it was part and parcel of the same.
Well, the reason why I say that, Your Honor, is because Dr. Brown was the last witness to testify at trial. Then you had the defense closing argument. The defense attorney did not even mention PTSD in that closing. He actually did refer to Dr. Brown. He said something along the lines of, well, you heard Dr. Brown, but you know what? Just use your common sense. This was an individual who was shot at near his friend 8 months before and was shot 5 days before by Kevin Parker. So just use your common sense and think about that he was stressed and he was paranoid. And I think the defense attorney argued that because the PTSD claim was weak. And I think the prosecutor did a good job attacking that defense, attacking the credentials of Dr. Brown, but also pointing out—
Attacking the credentials? I didn't see that part.
He pointed out that Dr. Brown did not list PTSD as an area of expertise on his CV, that he had no published articles about PTSD, that he mainly published about asthma, and there was some discussion about the significance of the factors that led to the PTSD diagnosis, where it was on a scale of 0 to 90. When you reach a level of 65, that's when it becomes significant, and he testified that the defendant had scores of 66 and 67. But in addition to that, the defendant—
But you don't think this was ineffective assistance of counsel? You think it was a wise strategic decision in light of the way Dr. Brown's testimony had actually entered?
Yes, in addition to the fact that the defense was, he's hypervigilant, he's paranoid, he doesn't want to be out in public, yet there was testimony about the defendant's activities during this time. The day before the murder, he wants to go see his friend. He asks for a ride. He gets a ride to his friend's house. On the day of the murder, he wants to go see his friend again. He gets a ride and he goes there. After the murder, he goes to a public park to help warn his fellow gang members about possible retaliation. He flees to the Dominican Republic in the aftermath of the murder, posting pictures of himself on a beach, not the actions of someone that was hypervigilant, paranoid, or had PTSD. So I think it was not error for counsel to request that instruction because it was a weak defense, and it was not error because they had that instruction that they could consider everything relevant to the defendant's state of mind at the time. And when I said earlier that the evidence here was overwhelming in terms of deliberate premeditation, I'm referring to the fact this defendant testified that he obtained a gun a few days before this murder. He obtained that gun after the intended victim of this murder shot him. That when he first sees Kevin Parker, that intended victim in the cemetery, his first reaction is to exclaim, "F them, F them." And then with deliberate premeditation, he takes out his gun. He leans or hangs out of the window, which was testimony by several witnesses, clocks that gun back, and pulls the trigger 6 times. It only takes a matter of seconds to form an intent to kill. And when you look at all those factors together, that was deliberate premeditation by the defendant. And the defendant's actions in the aftermath of the crime also suggest deliberate premeditation. Literally, while they're still in the cemetery, he orders his associate at gunpoint to get rid of the murder weapon. And he goes, that was Mr. Taylor. He went and hid the gun wrapped in a t-shirt in the cemetery. He goes to a friend's house, wipes down the car, cleans the car, smashes his cell phone, and then goes to to a public park to warn his gang members about retaliation. And then, as I mentioned, he flees to the Dominican Republic. And I think the case law is pretty clear that flight is classic evidence of consciousness of guilt. So considering the overwhelming evidence of deliberate premeditation,
Photographs of him on a beach in the Dominican Republic reflective of consciousness of guilt.
The photographs in the Dominican Republic were proper consciousness of guilt evidence.
Why? Yeah, that's my question.
Oh, yeah, okay. Okay.
You
So,
can't answer the
yes,
question by
yes,
saying it is so.
Yes. It was proper consciousness of guilt for what I said. This was a defendant fleeing the country.
Right, the flight
Yes.
is consciousness of guilt.
So
But
consciousness of guilt.
So explain to me how the photographs of him on a beach support.
Again, he's on a beach. This is a few weeks after the murder. This goes to the defendant's whole theory of PTSD. I'm paranoid. I'm avoiding other people.
Right,
I'm staying inside.
So it goes to that. It doesn't go to consciousness of guilt.
I think it's relevant to both. I think the fact that he...
Explain the consciousness of guilt relevancy.
Yeah, so there was testimony that the defendant went to Dominican Republic, and I think it was important for the Commonwealth's case to also show not only is he there, he's not only posting pictures of himself on the beach. It was coupled with those Facebook posts that all the prosecutor brought those up around the same time during the cross-examination. So he's posting the pictures, but he's also posting these messages that God protect me from my friends because I can take care of my enemies. I'll never drop my stripes because I earned too much to get them. So all of that, both of those. So what I'm trying to argue is it was relevant to the consciousness of guilt because the Commonwealth could actually show he's in the Dominican Republic, and look, he doesn't seem to be too paranoid about being out in public.
He's sort of flaunting it.
Exactly. And in terms of the delayed disclosure that was discussed, I'll just say that the motion judge in this case found there was no bad faith on the part of the Commonwealth. And it's interesting because he came to that conclusion essentially using the arguments that the Commonwealth made in the lower court of why this was actually not late disclosure. And because of that, because there was actually...
Explain that.
Of course. So when it came, so the Fred Taylor letter,
That was disclosed as part of the grand jury minutes, or?
Yeah, so that was, the contents of the letter were discussed during the grand jury testimony of Judicial de los Santos. The letter was introduced as an exhibit at the grand jury.
What about the Facebook posts?
No, I'll discuss the Facebook post. So you want me to discuss the Facebook post?
Yes, because I think I
Sure.
understand the Taylor letter.
So the Facebook posts, as the prosecutor stated in his affidavit, were obtained prior to the defendant being charged, prior to any indictment. There was a search warrant for his Facebook account. The prosecutor stated in his affidavit that he turned over all the Facebook material to the defendant's first attorney, and that he didn't know whether that first attorney, turned over the entire file to the second attorney. And I would argue that as I did in the lower court, there was evidence that those posts were turned over because counsel at trial said, "Oh, I have the photos, I just don't have the posts." The post and the photos came as a result of that search warrant that was conducted before the defendant was charged. So I think, well, of course, I would have liked the motion judge to have found that those Facebook posts were turned over because it was clear counsel had some evidence related to the Facebook account, but instead he used that to say, well, pointing to that, I don't find bad faith on the part of the Commonwealth.
So moving away from the question of bad faith and just the question of improper failure to disclose, is the fact that the contents of the letter were discussed in the grand jury minutes, does that excuse the Commonwealth's not turning over the letter pursuant to Rule 14?
Again, I maintain that it was turned over, but I think it sort of goes to the defendant's claim and what defense counsel said in his affidavit. He said he was blindsided by the letter. And I think looking at that statement from counsel, the motion judge could have actually discredited everything he said about the Facebook account because it was clear he wasn't blindsided. He had the grand jury minutes which discussed the contents of a letter, and he had the grand jury minutes where he knew that the letter was introduced.
But as I read your brief, you do not claim in your brief that a copy of the letter was turned over. Is that correct?
This is why the motion judge decided it, found the late disclosure because of this. In the Commonwealth's first notice of discovery, he listed several grand jury minutes, and he also included in that list the exhibits from those grand jury minutes. However, in the second notice of discovery, where these grand jury minutes at issue, where the letter was discussed, the prosecutor only put the minutes and did not also specify that the exhibits were turned over. Obviously, I wish he had specified that it was turned over, but considering that he turned over all the exhibits in the first notice of discovery, I think the judge could have found that that letter was turned over. But he couldn't point to anything that the Commonwealth actually did that.
Can I ask you to address the delayed disclosure of the defendant's statement to officers that he was not a gang member?
Yes, so the prosecutor was familiar with that case, so he had some knowledge of that. Had knowledge.
This prosecutor knows of information that is going to be used to impeach the defendant. Why is it not?
No, I'm suggesting that he knew about the Obang case. And look, the question about whether or not he was a gang member and the prosecutor's use of that prior inconsistent statement to impeach him, I mean, quite honestly, I don't think it did much for the Commonwealth's case. It was the defendant testified he was a gang member.
So your position on that is that no prejudice by the delayed disclosure?
Correct.
Okay.
And that rule, yes. And if there are no further questions, Your Honors, the Commonwealth can rest on its brief.